I want to tell you about a man named Gerald. Gerald was 68 years old. He was healthy, active, and sharp. He had a pension, a savings account with $240,000 in it, a home that he and his wife had lived in for 30 years, and a wife he had been married to for 41 years. And then one morning, Gerald had a stroke. He did not die. That is the part people do not expect. Gerald survived. But for 11 weeks, Gerald could not speak. He could not sign his name. He could not make phone calls or write checks or authorize any financial transaction of any kind. During those 11 weeks, Margaret could not access their joint savings account because the bulk of that account was in Gerald's name alone, and the bank would not release those funds without his signature or legal authorization. She could not speak with his financial advisor. She could not make any decisions about his medical treatment because the hospital had no document giving her that authority in writing. Margaret had to hire an attorney and file an emergency petition with the probate court just to gain the legal authority to manage her husband's finances and work with his medical team. It took 6 weeks to get through the court process. It cost them $4,000 in legal fees. Gerald eventually recovered. But the entire family was shaken in a way that took years to fully process. Here is the thing. Every single problem his family faced could have been prevented with one document. A document that costs less than $1,000 to prepare properly. A document that most people do not think about until they desperately need it, and by then, it is too late to create one. That document is called a power of attorney. I am Marcus Webb, and this is Benefits Decoded. Today, we are talking about the most overlooked document in estate planning. Not a will, not a trust, a power of attorney. And specifically, what happens to real families when they do not have one? Here is what we are covering today. What a power of attorney actually is, the 2 types every adult needs, what happens without one, the hidden costs families pay, the 5 most common mistakes people make, and the exact steps to get your documents in order before life makes that decision for you. Chapter 1. What a power of attorney actually is. A power of attorney is a legal document that gives someone you trust the authority to act on your behalf. The person who signs the document is called the principal, that is you. The person you authorize to act for you is called the agent, sometimes called the attorney in fact. I want to make something very clear right away. The word attorney, in this context, does not mean a lawyer. It means representative. You are authorizing a trusted person, a spouse, an adult child, a sibling, a close friend, to act on your behalf when you cannot act for yourself. There are 2 main types of power of attorney that every adult in America needs to understand. The first is a financial power of attorney, also called a durable power of attorney for finances. The second is a healthcare power of attorney, also called a healthcare proxy or a medical power of attorney. These are 2 separate documents, and in almost every situation, you need both. I want to say this as clearly as possible. A power of attorney is not just for the elderly. It is not just for people with serious health conditions. It is for any adult who could ever face a situation, an accident, a sudden illness, a surgery that does not go as expected, where they temporarily or permanently cannot manage their own affairs. That is every adult on this planet. Chapter 2. Financial power of attorney, what it does and what happens without one. A financial power of attorney gives your agent the authority to manage your money and property on your behalf. The scope of that authority depends on how broadly or narrowly you write the document. But in general, a comprehensive financial power of attorney includes paying your bills and managing your bank accounts, filing your tax returns, managing your investments and retirement accounts, buying or selling real estate, and handling your mortgage, your insurance policies, and any outstanding loans. Most people hear that list and think, my spouse handles all of that already. But here is the reality. Without a legal document granting your spouse that authority, when you become incapacitated, your spouse does not automatically have the legal right to act on your behalf with financial institutions, courts, or government agencies. They may have access to joint accounts. But accounts held in your name alone, without legal authorization, those can be frozen. Now, let me explain the 2 critical distinctions you need to understand about financial powers of attorney. The first distinction is between durable and non-durable. A non-durable power of attorney is active when you sign it, but it expires the moment you become incapacitated. Think about how backwards that is. The only time you actually need someone to manage your finances for you when you cannot do it yourself is exactly when a non-durable power of attorney stops working. This document is essentially useless for incapacity planning. A durable power of attorney remains in effect even after you become incapacitated. For estate planning purposes, this is almost always what you want, a durable financial power of attorney The second critical distinction is between immediate and springing. An immediate power of attorney is active the moment you sign it. Your agent can act right away. A springing power of attorney only activates when a specific condition is met, usually when a physician certifies in writing that you are incapacitated. Springing powers of attorney sound appealing on paper. Your agent cannot act until you truly need them. But in practice, they create dangerous delays at the worst possible moment. When you are in a hospital bed and your family needs to access your accounts to pay your mortgage, the last thing they want is to wait for certifications from two separate physicians before a bank will cooperate. Most experienced estate planning attorneys recommend immediate durable powers of attorney with a thoroughly trusted agent. Now, let me tell you clearly what happens without a financial power of attorney. Without a financial power of attorney, if you become incapacitated, your family must petition the court for what is called a conservatorship or financial guardianship. This is a formal legal process through which a court appoints someone to manage your finances. Even if that person is your spouse of 40 years, even if it is obviously your adult child who handles your affairs, even if every single person involved agrees on who should be in charge, the court must still appoint them formally. The court process for establishing a conservatorship typically takes between 3 and 6 months from start to finish. During that time, your accounts may be inaccessible, your bills may go unpaid, your mortgage may fall behind, your investment accounts may sit frozen during a market that does not care about your family's situation. It costs between $2,000 and $10,000, sometimes considerably more, just to file and receive the initial court appointment. And after the conservatorship is established, the work does not stop. The conservator must submit detailed annual financial accountings to the court. They must follow court-imposed restrictions on how they can use your money. They may be required to post a bond, essentially insurance against financial mismanagement, and that bond has an annual premium that comes out of your estate every year. A durable financial power of attorney eliminates the court process entirely. One document prepared by an estate planning attorney who knows your state's laws. Cost: somewhere between $300 and $1,000 one time. Your agent steps in immediately on day one with no court approval needed. Chapter 3. Healthcare power of attorney who speaks for you when you cannot. A healthcare power of attorney is a document that designates someone to make medical decisions on your behalf when you cannot make them yourself. This person is your healthcare agent, also called a healthcare proxy or healthcare surrogate, depending on the state you live in. Your healthcare agent can authorize medical procedures, surgeries, and treatments. They can decide whether you should be placed in a nursing home, a rehabilitation facility, or an assisted living arrangement. They can speak with your medical team, review your records, and consent to or refuse any medical intervention. And they can make end-of-life decisions in alignment with the values and wishes you have expressed to them directly. Without a healthcare power of attorney, things get complicated fast. Many people assume their spouse or adult children automatically have the legal right to make medical decisions for them. In most states, spouses and close family members do have some default legal standing to speak for an incapacitated patient. But that assumption breaks down immediately when families are anything other than perfectly simple, and most families are not simple. What if your adult children disagree with each other about your care? They both have equal default standing under the law. No one has final authority. What if your current spouse and your adult child from a previous marriage have genuinely conflicting opinions about your treatment? State law cannot resolve family dynamics. A healthcare power of attorney gives one person clear, unambiguous legal authority, the person you choose. What if you have a committed life partner of 15 years, someone who knows your medical wishes and values better than anyone, but you are not legally married? In many states, that person has no automatic legal standing to make a single medical decision for you. A distant relative you have not spoken to in 20 years may have more legal authority than your partner of 15 years. A healthcare power of attorney puts you in control. You choose the person. You define their authority. You make it clear in writing who speaks for you, no ambiguity, no family conflict, no court process required. Chapter 4. Living wills and advanced directives, your voice when you cannot speak. A healthcare power of attorney tells the hospital who makes decisions for you. A living will tells them what decisions you want made. A living will, also called an advanced directive or healthcare directive depending on your state, is a document that expresses your specific wishes about medical treatment and end-of-life care. It answers the questions your family would otherwise have to answer in the worst moment of their lives. Do you want to be resuscitated if your heart stops? Do you want to be placed on a ventilator? Do you want artificial nutrition or hydration if you have no reasonable chance of recovery? Under what conditions would you want your loved ones to consider discontinuing aggressive life-sustaining treatment. These are not abstract hypotheticals. These are decisions that families face in emergency rooms and intensive care units every single day. And without a living will, those decisions fall entirely to your family, people who must make devastating choices without knowing what you would have wanted. Families who do not have a living will often face one of two terrible outcomes. Either they disagree with each other about what their loved one would have wanted, which can fracture relationships at the worst possible time, or they all agree without any real guidance to pursue every available treatment regardless of prognosis, not because they believe it is right, but because they cannot bear to be the ones who chose otherwise. The result is often prolonged suffering, extended hospital stays, and medical bills that drain an entire estate. A living will does not take the decision away from your family. It guides those decisions according to your actual values and wishes, so they do not have to carry that weight alone. There is also a document called a POLST form, which stands for Physician Orders for Life-Sustaining Treatment. Unlike a living will, which is a personal statement of your preferences, a POLST is an actual physician order signed by a doctor. It travels with you through the medical system, recognized by hospitals, nursing homes, and emergency responders. It is most often used for people who are seriously ill or elderly, and it carries immediate medical and legal weight in emergency situations. The most important thing I can tell you about living wills and advanced directives is this. Write down your wishes and then talk to your family about them. Tell your healthcare agent where the document is stored. Share your values directly and out loud. A document sitting in a filing cabinet that no one knows how to find is not useful when the EMTs arrive. Chapter 5. What the absence of a power of attorney actually costs. I want to give you a clear and honest picture of what it costs a family when these documents are missing. Not just in legal fees, but in time, relationships, and quality of life. The financial cost of a court-ordered conservatorship runs from $2,000 on the very low end to $10,000 or more just for the initial filing and court appointment. As I mentioned, that is only the beginning. After the conservatorship is established, there are annual court accountings that typically require an attorney to prepare, bond premiums that recur every year, and ongoing court oversight that does not end until the conservatorship is terminated. Over a 5-year conservatorship, which is not unusual when a person becomes incapacitated in their 60s, total legal costs can easily exceed $20,000. Compare that to a complete power of attorney package, durable financial power of attorney, healthcare power of attorney, and an advanced directive prepared by an experienced estate planning attorney. The typical cost, $300 to $1,500. One time, the emotional cost is harder to quantify. When a family is managing a loved one's illness while simultaneously navigating a court process that could have been avoided entirely, the pressure is extraordinary. Adult siblings who might otherwise support each other begin to argue about who should be in charge. The person who is ill, if they remain aware of what is happening around them, often feels crushing guilt at what their family is going through because of a document they never got around to signing. There is also the very specific danger of frozen assets. When someone becomes incapacitated without a financial power of attorney, before any conservatorship has been established by the court, assets held in their name can become completely inaccessible. Mortgage payments fall behind, bills go unpaid, investment accounts sit frozen, creditors do not pause their operations because someone is in the hospital. And consider this, what if you become incapacitated outside of your home state? If something goes wrong while you are traveling, even just a few states away, a court-ordered conservatorship from your home state may have limited standing where you are. Your family could potentially need to begin the court process from scratch in a jurisdiction they have never set foot in. A valid, durable financial power of attorney is generally recognized across state lines. Your agent can act on your behalf wherever you happen to be. Chapter 6. The 5 most common power of attorney mistakes. Let me walk you through the mistakes I see most often, because getting these documents wrong can leave your family in nearly as difficult a position as having no documents at all. Mistake number 1. Naming the wrong agent. The most common version of this mistake is naming your spouse as your only agent with no designated backup. If your spouse dies before you or is incapacitated at the same time you are, your document names an agent who cannot serve. Always name at least one backup agent in both your financial and healthcare powers of attorney. Mistake number 2. Using an outdated document. A power of attorney you signed 15 years ago with a named agent who has since passed away is a liability, not a protection. Old documents may not comply with current state requirements. Named agents may no longer be appropriate. Review your power of attorney documents every 3 to 5 years, and after any major life change, marriage, divorce, the death of a named agent, a significant move to another state, Mistake number 3, using a generic online template without professional legal review. Every state has its own specific requirements for a power of attorney to be legally valid witness requirements, notarization rules, sometimes specific statutory language that financial institutions are required to honor. A generic template that does not comply with your state's current requirements may be rejected by banks, hospitals, and courts at exactly the moment your family needs it most. The cost of having an attorney prepare state-compliant documents is worth every dollar. Mistake number 4, not telling your agent where to find the document. Your agent cannot act on a document they cannot locate. Store the original in an accessible place, not in a bank-safe deposit box that requires your presence and a key to open. Give a signed copy directly to your agent. Keep another signed copy on file with your estate planning attorney. Mistake number 5, signing a power of attorney after cognitive capacity has already declined. A power of attorney is only legally valid if you were mentally competent at the time you signed it, legally capable of understanding and entering into a legal contract. If a person signs this document while already experiencing significant cognitive decline or incapacity due to illness, the document can be challenged, invalidated, and set aside entirely. This is the mistake that cannot be undone. Power of attorney must be executed well before it is needed. Chapter 7, 3 actions to take this week. Action number 1, find out whether you already have a power of attorney. Check your estate planning files now. Do you have a current durable financial power of attorney? A current healthcare power of attorney? A living will or advance directive? If you are not sure, call the attorney who prepared your estate planning documents. Many people received these documents years ago and have simply misplaced them or forgotten they exist. Action number 2. If you do not have current valid power of attorney documents, schedule a consultation with an estate planning attorney this week. A complete package typically costs between $300 and $1,500 depending on your state and your specific situation. Many estate planning attorneys offer bundled pricing when you combine powers of attorney with a will or trust. Ask about that when you call. When you go to that consultation, bring a list of the people you trust most deeply, your potential agents. Think carefully about who has the judgment to make sound financial decisions in a crisis. Think about who knows your values and your wishes well enough to speak for you in a medical emergency. And think about backup agents in case your first choice is unavailable when they are needed. Action number 3. Have the conversation with the person you have named. Once your documents are signed and properly stored, sit down with your agent and walk them through your wishes. Tell them where the documents are. Tell them your values around medical care. Tell them what matters most to you, not just what is written on paper, but why. This conversation makes most of us uncomfortable. None of us want to think about losing the capacity to make our own decisions. But here is the truth. The people who avoid that discomfort are the ones who eventually pass all of that uncertainty, all of those impossible decisions, and all of that grief onto their families. At the worst possible time, here is the bottom line. Wills and trusts protect your family after you die. A power of attorney protects your family while you are still alive. Of the 3 core estate planning documents, power of attorney is the one most commonly overlooked, and it is the one that causes the most immediate damage when it is missing. Gerald's story ended well. He recovered, his wife and family got through it, but they spent 11 weeks in an entirely preventable crisis, and not a single one of them saw it coming. None of us do. If this video helped you see what is actually at stake, please share it. A parent, a grandparent, a sibling who has been putting this off. Not tomorrow, today. I am Marcus Webb. Thank you for watching Benefits Decoded. We've also covered what happens when you die without a will and how a revocable living trust works. Both of those are linked in the description below. Take care of your family. I will see you in the next one.